What justifies use of the certificate by private workers? Most private sector workers are not liable for federal income taxes under Subtitle A, absent an explicit liability statute. Thus, their use of the exemption certificate is legally sound and supported by case law and statutory construction. Executing such a certificate shifts the burden of proof to the IRS to demonstrate that a liability exists. Since no such liability is created by statute for private workers, the certificate lawfully prevents withholding and effectively nullifies any presumption of employee status within the federal framework. 15. What is tax evasion, and who can be guilty of it? Tax evasion is a criminal offense involving the willful attempt to evade a lawfully imposed tax. However, this crime presupposes a pre-existing legal liability. Without statutory liability, there can be no evasion. Therefore, only those individuals or entities for whom Congress has explicitly imposed tax liability, such as withholding agents, may potentially commit this crime under IRC Section 7201. For most American workers in the private sector, tax liability arises only if they voluntarily execute Form W-4, thereby placing themselves under the scope of the Public Salary Tax Act. Without that voluntary act, there is no statutory nexus establishing liability, and thus, no legal predicate for the crime of evasion. Why does IRS Form 1040 not require a notary public? IRS Form 1040 lacks a notary requirement because of 28 U.S.C. Section 1746, which allows declarations made under penalty of perjury to substitute for notarized affidavits. However, this statute distinguishes between declarations executed within the United States and those made outside the United States. The latter format, used when outside the United States, includes the phrase "under the laws of the United States of America." The deliberate inclusion of this qualifier reveals a critical legal distinction. United States refers to federal jurisdiction, i.e., the federal zone, while United States of America denotes the 50 states united under the Constitution. What is the constitutional implication of this distinction? The fact that Form 1040 uses the format applicable within the United States without reference to the United States of America strongly suggests that it is intended for individuals operating within federal territory, not the 50 states. This form of silent jurisdictional limitation undermines the assumption that Form 1040 is universally binding. Consequently, individuals domiciled within the states may reasonably argue that they are not within the territorial reach of IRS enforcement absent clear statutory authority. The form's signature structure implicitly supports the view that federal income taxation is geographically and jurisdictionally limited to the federal zone. Does the term United States have multiple legal meanings? Yes. The term United States carries at least three distinct legal meanings, as articulated by the U.S. Supreme Court in Hooven and Allison Company v. Evatt, 324 U.S. 652, 1945. It may refer to 1. The sovereign national government in international law. 2. The territory over which Congress has plenary authority, including federal possessions and enclaves, and 3. The collective union of the 50 states under the Constitution. This ambiguity creates serious constitutional implications. The IRS and other federal agencies often exploit this fluid definition to imply jurisdiction over individuals and property located within the 50 states, without explicitly stating which United States is being referenced in their regulations and forms.